I have Samson Lardi Anyenini on the line. We can get some further education from him. Samson, good morning.
Morning, good.
Now, this is rather unprecedented, is it not?
Removal of a holder of an independent constitutional body, and this is the line it takes. That will not be unprecedented. I led the case for the removal of Charlotte Loretta Lamte from track. I led the case to the Supreme Court against the removal of Charlotte Osei from the Electoral Commission. So we have history, and even before that, there was an NCC commissioner who had also been removed through an Article 146 procedure, which is a matter after I had completed doing the Rotalante case. Wrote a thesis about.
I suppose by unprecedented, what I'm saying is that a previous office holder is petitioning to remove his successor.
The previous office holder, we have seen since he left the office, the evidence has been clear that the appointment of Kiseja Bing is something that he doesn't support, and he has given some of the most flimsy or flimsiest excuses, about why Kiseja Bing should not be the special prosecutor. His attack on the institution after he left, sometimes you feel it's a case of someone succeeding where you failed, so you don't want to see them succeed. Unfortunately, sometimes that's how you are left to interpret it. But seeing all that we have seen happen to Kiseja Bing, and I suppose the large part which may not have been put in the public domain, including that there was a demand on him to resign because his continuous stay in the office had become untenable somewhat by a certain class. It may not be that surprising, but this is a procedure that is set up, a very good procedure, rather than allowing sort of a one-man process where you can be removed at the whim of someone else.
You were involved in the Charlotte Osei matter. Actually, you were on the side of the EC chair.
I did that case.
Yes. Afterwards, a lot of the commentary suggested that the process is set up in such a way that if you actually do want to remove someone from such an office, you can find reason, no matter what. I mean, this stated misbehavior thing, a lot of the criticism around how that process unfolded was that, well, in essence, those who wanted her out there was always going to be a way for them to achieve it. Do you feel that applies generally to this sort of process?
A general application will be difficult because of my experience. For example, in the Charlotte Osei matter, which I led the Kubako as lawyer to the Supreme Court to challenge the removal. The basis included that procurement breaches had a procedure or had a specific legal stipulation for dealing with. And many people get involved in procurement breaches. When they do, it is the Procurement Act that is applied to sanction them if what they have done will not be, as it were, ratified.
Yeah.
But in that case, if you are not even ratifying them, and we have seen, if you see even the SML matter and what we are told about the ratification that took place. Once the appointer likes you, or somehow they are connected to what you may have done, and so do not want you removed, they will do everything to keep you. So to that extent, you're right. They can use the process by way of abusing it to remove a person from office. The safeguard in the framers, in the mind of the framers of the Constitution and Article 140, has been to ensure that if the CJ is the one to do a prima facie, and so, for example, when my client, Richard Nyama, petitioned Chief Justice George Inawu, petitioned the President, and he went to Chief Justice George Inawu to make the prima facie determination. There were several petitions. Many people had filed petitions, but their petitions did not carry favor because they didn't couch and they didn't provide sufficient evidence. But because we had done it and done it well, he was able to make a prima facie determination, and then the committee was set up. Yeah. So people make allegations that where that is supposed to be the safeguard, the CJ will do it. If it's a flimsy matter, they will throw them away. And then the committee that will be set up, 3 justices of the Supreme Court, of the Superior Court, and then the 2 other people. The appointment, it is hoped that the CJ is an impartial person, is somebody who is involved in, that decision making. So they will not pick people who will do the bidding of a government or the appointer or whoever wants the person removed. But yes, the potential for abuse is there. We have presidents who have received petitions and never forwarded them. We have situations we understand CJs may have received petitions and just ignore them. Yeah. But in the OSP Act, is the reason there was an attempt to cure it in the OSP Act. So when President receives it, you don't have the pleasure to keep it forever. You must forward it within 7 days. And then whoever has to, the CJ to has a certain period to do some work on it. So yes, there's room for it to be abused. But it's a very effective and better means of, setting, as it were, holders of such sensitive offices.
Right. Now, as we learned from the law, the Chief Justice now will set up a committee which will have 1 Supreme Court judge, 1 established lawyer, and then 1 other person. In your experience, this other person, what sort of other person would be suitable for such a role? What sort of other person would the Chief Justice be considering?
Well, I think, as you said, being novel, first time we're going to use the OSP's law's prescription for such a process, I would expect that people with legal training would always like to use precedent. So if the Constitution provided for, some civil servants to be brought on the process, and this particular provision doesn't provide and say other persons, they will be more minded to look for somebody like that. They will look also for someone in CSOs. That it's discretionary. So
it does say someone with investigative experience. So maybe that would be the one criterion. Apart that the Chief Justice.
Sorry.
It does say that the one person, the other person, should have investigative experience.
Yes. So it most likely will be somebody from maybe the police, the CID, or some context like that. Yeah.
Right.
But it's still discretionary though, up to where the person will come from.
Okay.
Except that they must justify that they have a certain experience.
I mean, Samson, just curious and finding out. So one of the grounds for his removal is bringing the name of the judiciary into disrepute. And based on the principles of natural justice and not being a judge in your own court, how is it possible, for instance, that the same institution in whose name, I mean, the same institution whose name he's bringing into disrepute is allegedly, so pretending the process of his removal?
Well, it wasn't contemplated. This is in the law. So it wasn't contemplated. It just, you could say, a matter of a coincidence that the judiciary has to be the one, or the CJ has to be the one to lead this process. Especially in a situation where clearly it's been public. And the SP had to speak to the press and talk about his frustrations about the conduct of, certain judges in certain decisions and so on. We will have to trust that judges or the judiciary accommodate criticism. And when the criticism is such that there's evidence to it, it is not taking and there's not a ganging up. And that's irrespective of what the criticism is, that the members of the judiciary, even including the head of the judiciary, feel hurt about, then they will still, do a job that does not leave people thinking and making conclusions and inferences that, this is what has happened. But it sounds like a bit of a peculiar situation. And you are right about raising the issue of the rule of natural justice. The rule of natural justice has two legs. One says you should be given a fair hearing, meaning you should not be condemned without being heard. The next says a person should not be a judge in their own cause, which means if you are the one affected, you should not sit on the panel to judge the person who is accused. So that throws up a bit of a problem here. You are right about it. It throws up a bit of a problem here, but we can only trust that there are people who rise above personal, stuff and can be professional in their conduct.
Is it the case that we have no way of curing that problem currently?
Because the law you read does not provide a room for it. It wasn't contemplated. That's what I said. Unfortunately, that it wasn't contemplated. So you can't do it any other way.
Samson,
those that must look at it are the ones the law has appointed must look at it. You cannot use any other procedure. Recently, we understood that when the special prosecutor complained about everything else, there was a meeting between the prosecutor and a group of select people that the CJ had put together. And so he was invited and he attended to a meeting where he was asked questions about some of these things. And he was very frontal in defending his position. So somewhat, that also may worsen the situation you are talking about. It may make it a lot more pronounced that they have had cause to also complain about what the petitioner is now complaining about, and they will now have to sit on it.
Yeah.
So we say I I'm thinking, look, the Special Prosecutor's Office, I take the view, and it's a view I take which allows me room to give it the support I feel it deserves because of what we find in our country as far as the corruption is concerned. The corruption is really terrible. For some of us, what we know, including what we cannot be talking about publicly, this country is doomed if we do not find a very effective way of checking the corruption. It's to the point that, particularly political leaders of the state can literally just be involved in the business of literally selling the country, so to speak. It doesn't matter how hard times are and situations are. Elsewhere, these offices do their press conferences. I've been familiar with the Nigerian situation and elsewhere and how they operate. But this is new to us. So we also have, particularly the judicial system is very slow to being receptible to some of these things. And so you hear people say, well, if you are a prosecutor, you should be feared, you should be hiding, you should never be heard. No, these are antiquated, they are archaic, and they don't apply to the Special Prosecutor's Office, at least the equivalence we have seen elsewhere.
Right.
But they were doing these things that would appear new to our system, and the system may respond in a certain way. Yeah, but, Martin Amidu has his right. If he's doing it genuinely from his heart, and he believes that there have been wrongs committed, as he claims, as you make us understand, that the petition says that because he has arrested certain people, and we know in recent times the people who are arrested, and that their rights were abused in the arresting process. I don't know how that will amount to misconduct for an investigator that is conducting their investigative business. Otherwise, if there is no immunity, if you check the Special Prosecutors Act, there are actually immunity against some of these things, and it applies to even judges. They enjoy immunity in the course of their work from being accused of, in their judicial execution of their judicial duty, that a crime of sort is committed. But of course, all of those have exceptions.
Right.
I can't see how that works. That Martin Amidu himself applied makes an RTI request, and he says, give me the letters of appointment of the people you have in here, and they have issues with it. And then how that ends up becoming a matter of misconduct, which is grounds for removal. Well, let's leave it to the process.
Samson, the issue of the potential perversion of the rules of natural justice. I'm wondering if this was a court case and the court felt like one of the issues was beyond its jurisdiction. They could simply strike that particular charge off the sheet. Can a committee do that in a situation where there are a number of different charges, if you will, leveled against the special prosecutor? Can they say, well, this one does not fall under our jurisdiction because we would be presiding over a matter that we are parties to, so this particular one we cannot sit on it, but we will sit on the rest? Does a committee have the option of doing that?
In a certain sense, the committee is not a judicial committee. And in the purest sense, and as I have written about in my article long before, it is an administrative function that the CJA is performing, not a judicial function. But it is the person here, the person and the offices they belong, that bring what smacks of a conflict. As far as the question and the issue you are raising about natural justice is concerned, if it's a judge and the judge is sitting on the matter, some of them, are straightforward. They would recuse themselves. They would simply say, look, I have something to do with this, and so I shouldn't be sitting in judgment in the matter. I've appeared before court, in the Court of Appeal, and there's a matter, and Justice Dennis Ajay, up front, tells me, counsel, I have had something to do with this matter when I was in practice as a lawyer, and now you are you are coming before us. I want to recuse myself. I looked at him and I said, I trust in you that you will do an impartial work. So please don't recuse yourself. Go on. Then he asked me the question the second. I said, yes, go ahead. I'm ready to entrust it in your care to deal with it, because I have confidence in you as a judge and know that you are ethical and you will do a professional job and not allow your previous, encounters with this case to influence what you have to do. So if it were a case, a judge will recuse themselves, but not say, I will strike out a particular ground because I don't have the competence. But in the strictest sense, the committee is not a judicial committee.
Right. Well, if it's an administrative process,
constitutional framing of the committee, the judiciary dominates because of the three that will be there. But the SP's one has limited it, except that it is the CJ that's the appointment of those who will have to do this.
Right. Samson, I want to say a big thank you to you. I wish we had a bit more time. Maybe we have to come back to this a bit later, because lots of other interesting issues popping up on this one. It's a dynamic conversation.